This Safari Retreat judgment, one of the very important and fascinating aspect of this judgment is that in paragraph 25 of the judgment, the rules regarding interpretation of taxing statutes have been laid down in general. So that is
Yes.
something I think everyone will benefit.
Yes, right.
If you sir kindly tell him.
It's a good summary.
Yes, sir. It's a very nice summary, and it is in this matter where sir formulated this and decided rather that he will not press for the constitutional validity. Let Abrutos sir, who was leading the matter for Safari Retreat, argue on the point of constitutional validity. Sir said that I will focus only on the interpretation, that the difference between clause C of section 17(5) and clause D, and you did not touch upon the constitutional aspect at all. So now I will leave it to sir to discuss about this, what sir argued and how we got the judgment in our favor.
This judgment could not have been, we could not have worked so well cohesively as a team. But for the help of Vipin Jain, Vinay Saraf, I think we all worked as a team. We got input from everybody. And as he put it, when the matter first started, we discussed the matter, and I think one meeting we had and the matter was going to come next week. So when I came back to Madras, I was working on the planning the strategy. And I felt that one second. Yeah, I felt that the argument for challenging the validity itself will be very difficult, because after 4 decades of practice, it is extremely difficult to challenge a statutory provision. It is even more difficult to challenge a tax provision, because they say it's free play in the joints, government must have maximum leeway, this, that, and so on. And I thought that we could perhaps win on the basis of reading down the judgment. And I decided to focus on the difference between plant and machinery and plant or machinery. Vinay and Vipin all gave me the GST council meetings and so on. So here was an advantage of also having some experience in income tax. And I knew that the word plant has a very, very wide meaning under the Income Tax Act. In fact, in 1982-83, I had written a detailed article on what is the meaning of plant. It is not just an immobile structure. A dry dock is a plant. A fishing pond is a plant. Anything with which you can do business is a plant. In fact, the first decision on what is a plant is a judgment of Lord Rinley in 1886 or 1887, where he held a mule, there's a horse, is a plant, because he said something with which you do your business is a plant, something in which you do business is not a plant. So like a godown, etc. is not a plant, but any instrument of earning capacity will be a plant. And that article I wrote back, and subsequently there are a number of judgments which you can see under the Income Tax Act in definition of plant. And I decided that as a strategy, let us focus on plant and machinery, plant or machinery. And let us try to tell the court that, look, when you use the word plant or machinery, then the word plant is not defined. So you must understand it as it has been interpreted by the Supreme Court and the High Court. So jurisprudentially understand it as you have understood in various cases. We also found that plant or machinery is used only once, but plant and machinery is used at 10 times in the various sections. So we said that when they definitely wanted to use plant or machinery, there is a deliberate intent. There is a purpose for using such a word. And when they define the explanation, they put plant and machinery. They could have used plant or machinery also. So luckily that strategy worked. I was expecting that they may not uphold the validity, they may not strike down the validity. That also went according to what I was expecting the court to say. And finally, we succeeded, because apart from the law, you see, the whole point is that the government doesn't realize that just collecting more and more tax is not the answer. You are causing long-term damage to the economy. If you're going to have cement and steel at 28%, you're going to levy GST on the rent. But then you will say, I'll not allow input tax credit. What are you doing? You're only making our own cost of doing business much, much more. Just imagine if I have a logistics warehouse, you don't allow input credit. What happens? I'll only pass it on to the customer. Right? So, and I've always been fighting, apart from this webinar, I've always been fighting that look at, don't just focus on what is the GST loss. See that you may give up GST, but you'll get so much more by other indirect methods, through income tax, through other provisions of law. If your mall is cheaper, you'll have more footfalls, you'll have more business. See the overall ecosystem and just don't focus on only GST and income tax. So coming back to the topic, we finally succeeded on this issue of plant or machinery. Those of you who have read the judgment, as Vinay put it, one important takeaway is in all future cases, when you're interpreting taxing statute, you have a ready-made summary where I appreciate the Supreme Court for taking the trouble of culling out the essential principles. So this will be useful not only in the high courts and the tribunals, wherever we have to argue cases before the judicial fora or the quasi-judicial fora, we can use this judgment. Secondly, this judgment highlights the fact that when distinct expressions are used, in some places use plant and machinery, some places use plant or machinery, then there is a purpose behind it. It is not a mistake as the union tried to argue it's a clerical mistake or a arithmetical mistake. No. That is not the... So second takeaway is be very careful of the... Third important lesson is, which I also was told that what Mr. Palkhiwala has to do was, more than going to hundreds of authorities, try to read again and again the statutory provision. Keep on focusing on the statutory provision. Read it again and again. So you will get some answers. There's a story I'll share with you. There's a leading criminal lawyer called V.L. Ithiraj in Madras. He said, after so many years, whenever he had to argue a murder appeal, he would read 302, 304 again and again. So I try to follow it. If I'm doing section 32 Income Tax Act, I try to read the section first, see the section. And in a statute, every comma, every full stop counts, a semicolon counts, and so on. So that's the third takeaway, expression is very used. And the third thing is, you see, when you have a GST, try to see how this word is used in other taxing statutes. There is a cross-fertilization, if I may say so. Now, if you see the judgment, most of the judgment which has helped success in the case are income tax judgments. The Karnataka power judgment, that fishing pond judgment. Yes. So those of us who are doing indirect taxes, also please refer to direct taxation. If you're doing income tax, try to refer to excise. When I was doing income tax excise, I used till manufacture was defined in Income Tax Act. We would take into account central excise definitions of manufacture. If the word is sale, try to see what is the meaning of the word sale, because these are what is called in law nomen juris. These are words which are definite legal connotation, not just English words like sale or manufacture. Manufacture, as per the DCM case, is something which results in a new product, new use, new name. So the point I'm trying to make for all our benefit, because we are all students, every day is a learning process. So the thing is that try to see how the word is used in different statutes. There is, of course, once one Income Tax Act defines manufacture, then there is no need to go to excise. But if it is not defined, like in this case, plant was not defined, income tax came to the rescue, right? So this is the point. Now, going forward, what the court has said is they have applied that functionality test, which is again a landmark ruling, and it's a important development in tax jurisprudence. Functionality test. How do you decide what is a plant? So what is the function of that immobile property? Because all this difficulty came only in immobile structures. And plant and machinery, they have defined immobile structures to exclude. They say the civil works will not get it. Ordinary, the lathe or the generator fixed on it will be allowed. But they've excluded, if I'm not mistaken, telecom towers. One second, sir. Telecom towers.
They have excluded, sir, hotel and cinema.
No. In the section.
In section, yes, sir.
Yeah, they have telecom towers, pipelines, and land building and civil structures.
Correct, sir.
Explanation, yeah. And we consciously, I think, if I correct, Vinay, we said, see, now we have to get success for our client. We are not arguing in general. This is not a tax seminar. So we are not bothered what happens to theaters and hotels because they are not before us, and most important, they are not our clients. So we
Yes.
don't have to fight a general battle and get some overall thing. So other thing which you can also be, I learned over the years, is have a laser focus on what your client's interest is and stick to that. So you don't have to go into general principles and so these are the basic points. So principles of taxation, cross-fertilization of tax laws, functionality test, and the judgment also, what has happened is it has now left room for interpretation. On shopping malls, it has sent it back. And I think Vinay and others got me the Maharashtra rules on
Yes.
shopping malls, because we said, why is shopping mall different from a pure commercial building? Because shopping mall has separate building guidelines, building rules, etc., which makes it a thing not just for commercial renting, but it is for having shops, you have theaters, you have food, etc. So it has a special function. I don't know what the Orissa High Court will do now, but it'll be interesting to argue on functionality test. I only hope that they don't amend the law retrospectively in the next budget and say plant and machinery is the same as plant or machinery, then we are all finished. Yeah, yeah.